I'm grateful, my lord. Could we turn up, please, page 552? This is the Reed Farmiser case that I was referring to before, the short adjournment. This is a case that involved Section 214 of the Insolvency Act and wrongful trading. We get 2 points from this case in my submission. One is policy behind the Limitation Act, and second, the point that liability and remedy under Section 148 is discretionary, doesn't stop the cause of action accruing once the actual basis for the application is established. So I'm looking at Section 214.
I beg your pardon. Sorry, could you give me the page again, please?
Sorry, it's 552.
Thank you.
London, Reed Farmiser Court of Appeal decision. This points out that the remedy in respect of both liability and quantum depends on the discretion of court, because the court may declare that a person is liable to make a contribution, if any, to the company's assets as the court thinks proper. So it's a discretionary remedy in respect of liability and quantum. The liquidator made an argument that the words "if in the course of the winding up" meant that that was the only limit on when the application could be made. If it was made during the course of the winding up, it didn't matter how old the claim was. That was rejected, and it's at 554 by Lord Justice Peter Gibson. And it's at the bottom of that page, it's 8 lines up, where it says, on the contrary, it seems to me inherently improbable that Parliament would have would have intended that liquidators should be free to delay commencing Section 214 proceedings for as long as they chose, particularly when the directors were left entirely without any means of compelling the liquidator to take action.
Which page are you reading from?
So it's 554, my lord.
554. I thought you said 552. I mean, misheard you. Sorry. Right, it's about 8 lines up from the bottom.
Yeah, it's just
thank you.
In response to the submission that there was no, or that the limitation period would be simply determined by whether there was still a liquidation ongoing. That was the reaction of Peter Gibson, LJ.
I don't quite follow why you say this is a claim of the liability being discretionary rather than just the revenue. I mean, wrongful trading surely is, I'm not an expert on this, but it's not discretionary whether somebody's been wrongful trading or not, is it? Maybe what you do about it is, but...
Well, it's just in relation, well, perhaps if we come on to what was said at 557 at the bottom of the page, last 2 lines. Does the fact that the court has a discretion whether to make a declaration at all,
right,
a declaration of whether it's wrongful trading at all, even if it appears to the court that subsections 2 of Section 214 applies, and as to the amount of the contribution, if any, cause the claim made not to be in an action to recover any sum recovered by virtue of an enactment? I do not think so. I don't know if I'm just like invite your lordships to read until the end of that paragraph. The point we get from this case in my submission is that the fact that both liability and quantum are in the discretion of the court does not prevent the cause of action accruing once the facts upon which the application is made have been established. And in fact, in this case, the decision was that the cause of action accruing, this is page 552, upholding Mr. Justice Blackburn, that the cause of action accrued when the company went into liquidation. That was the last fact that had to be established in order to give the liquidator the right to apply for an order in respect of wrongful trading. And we submit that there's an analogy here between that type of jurisdiction and what we have under section 148C. In order for the claimant to succeed for an order for repayment of sums, they have to plead the facts which they say lead the court to conclude that there was an unfair relationship, and they plead the payments that were made. And once those facts are established, their right to apply to the court has accrued. The fact that the court may or may not make the order, it doesn't stop the cause of action accruing. And the fact that the claimant is expected to specify the order that they're after when they're applying, and we'll come on to this, shows why we've said in our written case at paragraph 41 that section 140A and B do not operate in isolation. In order to plead a cause of action, the claimant has to plead the facts which show why the relationship is unfair and the facts giving rise to the remedy sought. So if you're seeking a claim under section 140B for repayment, you've got to plead the fact of the fact you paid, as well as pleading the facts that the relationship was unfair. And that's precisely what these claimants did in this case. So the particulars of claim at 226 of the bundle. And if I might invite the court just to read paragraphs 11 through to 13. You've already seen paragraph 14, but 11 through to 13 pleads the facts that they rely on as giving rise to the unfair relationship. And it is precisely the facts that the Court of Appeal said gave rise to the unfair relationship. And those are entering into the PPI policy not knowing that a substantial commission was being paid to the bank, then making monthly payments to the bank not knowing it was receiving that commission, and the remedy that was sought was the amount that had been paid while the PPI policy was on foot. Nothing else was relied on in the claim. All of those facts were pleadable in the case of Mrs. Smith in April 2006 and March 2008 for Mr. Barr. Now, my learned friend relies on section 140A and the words is unfair. Now, the submission is that, as long as the claimant can come to court and say, my relationship is unfair, then there's no limitation point that can ever be taken against them, no matter how long ago the matters are that are being complained of. We respectfully submit that if one goes to page 337 and looks at section 148, what the use of the present tense is intended to the rationale why it was used is because debtors can be expected to make an application to the court during the currency of their credit agreements if they are faced with unfairness. One would expect if a debtor is being treated unfairly, they make their application to the court when they're being treated unfairly.
That surely is a very bold proposition to make in the context of these sort of claims, where you're dealing with consumers who may not, they may be very unsophisticated, lack education, lack resources. It's very common for claims arising out of credit relationships not to be brought until the relationship's been going on for years.
Well, my Lord, that's going back to a submission I made earlier on, which is that the limitation applies to consumers as well as businesses. And
I know, but you were just asserting that if that people are expected to come and say, "Oh, I've just made an extortionate payment last week," and if they leave it for 6 years, then they can never get their money back, even if the relationship goes on for another 10.
well, my lord, when one looks at, for example, some of the remedies that are aimed in section 140B, they're only of any utility if, in fact, they are awarded during the currency of the credit agreement. So reducing an amount outstanding, for example, or preventing a creditor from doing this or that. And, my lord, it's a point which is, in our submission, when one is trying to establish what was meant by use of the present tense in section 140A, it was because it was envisaged that those who were being treated unfairly would apply to the court when they are treated unfairly for the remedies in section 140B, which include stopping a creditor taking some action or reducing an outstanding balance. A learned friend's interpretation of is unfair is effectively that there is never any time limit on a consumer applying to the court for a remedy. If they can point to some unfairness which took place 30 years ago.
Well, it may have worn off, and on their submission, then you wouldn't have a claim.
Well,
I don't mean by that's not a limitation point, that's just a is it still unfair question.
yes, yes, although there's never been any concession that the events that took place years before in this case wore off, for example. The PPI.
It's all part of the circumstances, though, isn't it? I mean, if somebody's made payments 10 years ago and they did nothing about it, maybe in the context of the whole relationship, that doesn't make it unfair, particularly if they knew what was going on and could have complained sooner. But there might have been reasons why they were being exploited, or they were particularly vulnerable people who the situation might be different, and then you might say, well, it still does make the whole relationship unfair that they were making those payments 10 years ago.
Well, my lord, I
mean, Patel, one of the factors was that no information was being provided about the amount due.
Yes.
And so that may make a difference as to the fairness of the whole thing. Even though you may have made payments a long time ago, you might not claim them back because you don't realise perhaps the extent to which you were being ripped off, to put it in colloquial terms.
Lord, I will come on to Patel, my lord. Yes. It was simply a point that in my submission too much weight is being placed on the words "is unfair." If the relationship is unfair in section 140A, which effectively is giving the green light to consumers being able to apply at any point in time, no matter how long after the events in question took place. And I have to stress this is a primary limitation of the case. It's not about section 32. And if there are facts which mean right that the the debtor didn't apply for more than 6 years, if there are facts which fall within section 32, then of course they can make their application later. Now, my lords, could I move on to the Court of Appeal's analysis? And we've summarised that in paragraphs 45 to 49 of the written case. In our submission, it's straightforward. If we go to page 157, we read paragraphs 9 and 10. The Court of Appeal applied full assumption speech in Plevin. And in short, what made the relationship unfair is entering into a PPI contract and paying premium, not knowing that a large part of what was being paid funded a commission to the bank. Now, Plevin was a single premium PPI policy, here the premium is paid each month, and the PPI policy remains whilst it remains on foot. So the relationship was unfair when Mr. Burrell and Miss Smith were paying premium and not knowing that a large part was funding a commission to the bank. But as the Court of Appeal point out at 64, paragraph 64 to 65, which are on page 174, relationships can change over time, which is something we understand the appellants seem to accept in paragraph 44 of their submissions. So the relationship can move from fair to unfair and the other way around. And at paragraph 66 to 68 on 174, the Court of Appeal explained why the relationship was unfair whilst the PPI was outstanding, but fair after that. And in short, it's because of the non-disclosure of commission that the relationship was unfair when the initial decision to enter into the PPI policy was made. It was unfair each month when the PPI premium was paid, and whilst the customer had a loan liability referable to PPI, the Court of Appeal held that was unfair. But when the policy ended and there were no payments outstanding referable to PPI, the relationship was fair.
Why does it become fair when they've still got the money and they haven't disclosed the fact that they've received any commissions?
And they're in a continuing contractual relationship. They have a credit relationship. The credit relationship continues.
Yes.
But there's no disclosure.
No.
They're unable to take action.
Well, in other words, that is a Section 32 point. We have to, in my submission, approach this case on the basis that there are, these facts were known to the claimant, that they don't have any.
This is not a Section 32 point because we're talking about the fairness of the relationship as a substantive claim before we analyse whether it's time barred or not.
Yes,
and one factor is how much, it's undoubtedly a factor in fairness, how much information the creditor provides to the debtor. It's a very important factor in any credit relationship.
Well, Lord, it is, as the Court of Appeal held, that's relevant when somebody is making payments of PPI premium. It's relevant to know what the commission was at that point in time. But once that policy ends, there are no obligations referable to it, then it can no longer be said that the relationship is unfair. And that was the decision of the Court of Appeal. And we, with respect, support that decision. It's said, and that's because one has to look at what it is that is said to be unfair about PPI, and it is, in our submission, making payments in ignorance of the fact that part of what you are paying is funding a commission to the bank. When that policy is got rid of, and all that's left is a credit card agreement, that relationship is then fair. Credit card agreement that everyone who has a credit card enjoys, that you can buy goods and services on it. There's no complaint about that credit card.
By that relationship, do you mean the whole relationship, viewing it as an entire entity, as we're invited to do in Section 140A, historically, is now fair? Or do you mean you can just sever a separate relationship and call that fair and, as it were, jettison what happened before?
Well, it's not jettisoning it, my Lord. It is, the relationship is fair, as the Court of Appeal held, but the previous relationship, while the PPI policy was in place, payments were being made, that is unfair, and the customer has a cause of action to recover the payments that they made whilst the relationship was unfair. And they have 6 years in which to do that.
You say that the unfairness was making payments in ignorance. That remains a feature of the relationship, doesn't it?
Well, what's different, my lord, is that the customer is not doesn't have a PPI policy.
No continuing payments, but there's payments. There's no continuing payments, but those payments have been made.
Yes.
That's a fact of the relationship.
The fact that payments have been made, my lord, yes. That is a fact, but the question is whether the relationship after those payments have been made and after policy is ended is unfair. And in our submission, the Court of Appeal was right to hold that it is not unfair after that date.
But doesn't Section 140A, as we're submitting, require the court to consider the whole duration of the relationship? It's one relationship going back to when, and indeed before, the making of the credit agreement.
Well,
it's an entirety. You can't just, as it were, hive off a bit of it and say, well, actually, it's all right now.
And the Court of Appeal didn't hive off any part of the relationship, my lord. It considered all of the relationship all the way until the end of the credit agreement. And its conclusion was that at the end, the relationship was fair. The PPI policy in Ms. Smith's case had not been in existence for some 9 years. She hadn't paid any PPI premium for 9 years. And that was the Court of Appeal's, it was the Court of Appeal's analysis that, well, it was unfair whilst PPI premium was being paid under the PPI policy, and indeed unfair whilst there was PPI outstanding on the credit card. But after that, the relationship was fair, particularly in 2015, which is some 9 years after the last payment referable to PPI.
May I ask, did the Court of Appeal approach it in that way, though, or did they simply say that once the economic effect, as they put it, had ceased in terms of making further payments, it ceased to be unfair, even though the customer remained in ignorance, the consumer remained in ignorance?
Yes, my lord, it was the relationship was unfair when the economic consequences of the PPI policy ended.
Mm. Is it right to say the economic effect or consequence ended when they stopped making payments?
In my submission, yes, my lord, there was no further obligations to make any payment under the PPI policy.
But they were out of pocket for those they'd made.
Well, my lord, they had a claim to recover those sums which had accrued at that date. And that, in our submission, is the distinction. The ongoing relationship arose out of a credit card. And what they had was a claim in respect of previous unfairness arising out of a relationship which arose out of a credit card and a PPI policy. And, my lord, it's been suggested in paragraph 54 of Malone Friends skeleton that, written case, that the Court of Appeal's approach to identifying the unfairness caused by PPI is inconsistent with that of Lady Justice Rose, as she then was in Potter and Canada Square. Perhaps if I just give you, Your Lordship, the reference, it's at page 782 of the bundle, but in our submission, what Lady Justice Rose was describing as the unfairness of making payments under PPI is entirely in line with the Court of Appeal's analysis, namely that it is the making of payments in ignorance of the fact that a commission is being paid to the bank. And the Court of Appeal added, and also whilst that sum is still outstanding on your credit card. And nothing in Lady Justice Rose's judgment in Potter undermines that analysis as to why the relationship that Miss Smith had in 2015 was fair, given that all the obligations referable to PPI had ended some 9 years previously.
This is the appeal for which judgment remains outstanding. Canada Square.
Yes.
Yes, my Lord. It's just
Yep.
a description of why the.
No, I understand.
Yes. My Lord, the Court of Appeal's analysis is that the relationship after the PPI policy ended and all payments referable to it had been paid off arose out of the credit card agreement. That was a fair relationship. And the fact that Miss Smith had a claim against the bank is not something that arises out of the relationship that went on between the parties, that continued after the PPI policy had been ended. And it's important in my submission, Lord, to understand the consequences of Malone and Friends' case. It permits claims for repayment of money to be brought literally decades after the money was paid. So if we take an example, 25-year loan with an unfair rate of interest in year one, it's a variable rate loan. The rate in year one is unfair, but it's then returned to a fair rate for the remainder of the 24 years of the 25-year loan. On the appellant's case, a debtor could wait until after the loan had been repaid in year 25, and then wait another 5 years and 364 days before issuing their claim for the interest that they paid in year one, which by then would be some 30 years.
And you say that's a realistic example, what? Because the fact that the bank still had the benefit of the interest paid in year one, and the debtor still repaid the interest in year one, on their account, on their analysis, means that it's still an unfair relationship at the end of 25 years.
That's what they say, my Lord, yes.
Yeah.
The well was poisoned
Yes.
by year one.
Yeah.
Exactly, yes. That's exactly their case, my Lord. But those are the consequences of that analysis.
Well, if it's taken to that extreme point, but one answer to it would be to say, well, in your example, if you look at the entire at the 25-year relationship as a whole, the fact that a high rate of interest was charged for 1 year early on and no complaint was made about it doesn't make the relationship, when you look at it as a whole, unfair.
Well, that's
hopeless.
That's one analysis, my Lord. But another analysis is that, well, if you've been paying an unfair rate of interest, the Act gives you a right to apply to the court for a remedy. If you choose to do nothing about that for 6 years, then I'm afraid you can't come back in year 30 after the agreement has ended and ask the court to make a repayment which you could have asked the court to make during the course of the relationship within 6 years. And in fact, in practice, it means that limitation can never run against a debtor while the loan is still in existence. That claim for year one interest can never become time barred during the life of the loan. Now, my Lord, I want to move on to some of the other points that my learned friend made about the question of is it a yes or no question, and the date when the assessment should be made.
Your point, as I understand it, is what in practice pleaded against you as at 2015 could have been pleaded against you as at the 6th of April 2008, and nothing changes in the interim.
That's right, my Lord.
Yeah.
That's one point we make. But just in relation.
I know it's not your only point, but you then say, because you want to interpret the legislation consistently with the existence of limitation, the consequence of the claimant's submission is that there is no limitation until the agreement ends at all,
Yes.
albeit that you have an accrued right as at 2008.
Precisely, my lord. Now, Lord, and one can imagine cases where the episodes of unfairness are distinct, like they are in this case. There's a very distinct episode of unfairness when there was a related agreement, a PPI policy in place. When that ended, we say the relationship changed and became fair. But you can imagine that there would be other complaints that could be made. So there might be a distinct complaint about the rate of interest that was paid during a particular point of time on the credit card. And at 107 of the bundle, we just set out some situations which might arise involving different factual scenarios, where we say simply answering the question yes or no and at one point in time really doesn't make any sense. So it's paragraph 54 of our written case.
So what page? I thought you said 107.
Page 122.
122.
122, thank you. So it's paragraph 54, which sets out a diverse range of claims that can be made under section 140A by different people, sureties, for example, which can arise at different times. And we submit that can't sensibly be reduced if one was asked to make a ruling in respect of all of those claims by different people, which may arise at different times. It doesn't make any sense to say, well, the way to resolve this is to answer a simple question right at the end of the relationship, yes or no, is the relationship fair or unfair?
Well, why isn't that the first question? Because if it's fair, then end of story. If it's unfair, then you have to analyse the cause of what and what remedies is required to.
I'll come on to this, my lord, but one can imagine situations. Can I come on to that?
Yeah, of course.
As an example. So, to give an example, a learned friend's approach that there should be a yes-no question answered on the date of trial or at the end of the agreement, where there's a single determination date. It produces some, we would suggest, rather odd results. So, first of all, you end up with the limitation period commencing on the same date, despite the facts that are being relied on taking place at completely different times, and that the facts are completely different. So, to give you an example, imagine an 8-year car loan. The debtor has a complaint about interest that he's paid under his loan in year 1 only. Then in year 7, his car is repossessed by the by the creditor unfairly. Those are entirely different facts. They would seek different remedies. In respect of year 1, he'd seek repayment of the interest that he'd paid. In respect of the repossession of his car, he'd seek an order that would be delivered up to him. And the court would necessarily have to consider these different, disparate claims, which we do say are different causes of action, by reference to the facts that existed at the time the events took place. So the complaint in relation to interest would have to be determined by the court by reference to what were the rates of interest that were being paid at the time that you were paying this rate that you're complaining about. What was the market rate of interest, for example? But that's an entirely different question to that which would arise in relation to the repossession of the car, which is, well, why was it repossessed? what was the alleged ground relied on. Those are completely separate instances which could give rise to an unfair relationship. They cannot possibly, in our submission, be determined simply asking the question yes or no. Is it fair or unfair? The court necessarily has to go into the detail of what it is that is being complained of, when it took place, and what remedy is being sought in respect of it. And because you can have disparate facts under section 140A to C in different phases of a relationship, this is why the court does need to go back in time and look at what was the relationship between the parties at different points in time, which is precisely what the Court of Appeal did in this case. And really, the appellant's approach is to use the continuation of the credit cards as a means to postpone the accrual of causes of action, even though the fact that the credit card continues has no relevance to the claim at all. So the claim, for example, that unfair interest was paid in year one is completely unaffected by how long the loan goes on for. It's an irrelevant fact. But according to the appellants, the fact that it continues means that that cause of action never arises until the credit agreement ends.
Is that right?
No.
I mean, wouldn't a cause of action, I mean, wouldn't, on any view, leaving aside the transitional questions and the application of the Act, if one assumes that the Act applied to these these relationships as at 6th April 2008, they would have an accrued right of action there.
Well, that's what
but I think what the appellant is, I don't think the appellant is denying that, but what they're saying is that because the relationship goes on, you assess it as at any particular date. So each day that the relationship continues, they have a separate accrued right of action, right to the end.
I will come on to that, but that's the continuing cause of action analysis, that there are continuing acts or omissions that carry on, which keep the relationship unfair. And I'll come on to the tab.
But I think you said that that on the appellant's case, there wasn't an accrued right of action until the end.
Well, my lord, it's never been accepted that there is an accrued cause of action until the end. And
Perhaps it depends what you mean by an accrued cause of action. If you mean, I mean, they surely do accept that they could have sued then and they could have got relief.
Maybe my learned friend.
But maybe, I think on their analysis it's not true that they've got it up their sleeve, so to speak, so that they can, at a later point, sue for something that had accrued at a certain date without taking account of everything that's happened since then.
Yeah. I mean, day by day, they're getting
Yes.
new rights of action.
And my lord, in order to get a new right of action, one has to show a new fact, because the cases make clear that a cause of action accrues when you can first plead the facts necessary to succeed on your claim. And if you can't point to any new facts after that date which are necessary for your claim, then you don't have a continuing cause of action.
But does that mean on any consumer credit claim, so that covers a long history of a relationship that goes back a long way, let's say 25 years or something, you first look and see, well, what is it unfair now? What relief can you get? And then you strip out any relief that you could have got more than 6 or 12 years ago, and you can't get that. Is that how you say it works?
Well, no, my lord. If there is unfairness found within the limitation period, then the Court of Appeal's analysis is that the court then has a discretion as to what remedy to order. And as the Court of Appeal made clear, that can go back for as long as in time as the court thinks is appropriate.
Well, why is that if the principle is that once you've facts that give you a claim have accrued, then you've only got 6 years to claim, as it were, for that relief?
Well, Lord, that is our alternative case, the 6 year
Right.
point. Court of Appeals analysis is different, Lord, and
Oh, that's what I call the foot in the door analysis. That if you're in time, then you can get everything. But as it were, but otherwise you.
So it's paragraph 56. It's page 172 of the Court of Appeals judgment.
And you support that proposition?
This Lord, in 56, yes.
Yeah.
We have an alternative case, which I can come on to, but I think Lordships know what it is. Lord, the single assessment at the end of the relationship can lead to, we say, some very odd and unfair results. So as we say in our written case at paragraph 53 and 57, which is 122, paragraph 53 and paragraph 57 is on 123. Imagine that there is unfairness at a point in time, which gives a surety, a claim for an unfair relationship. Some action is taken against the surety that may be required to make a payment, for example. But subsequently, there are dealings between the creditor and the debtor which make the relationship subsequently fair. Now, on the learned friends analysis, a claim by the surety has to be assessed by reference to the now fair relationship between the creditor and the debtor. The court will ask itself, well, I know, surety, you made a payment 2 years ago, which you say were an unfair circumstance, and you've come to court now seeking relief, but I'm afraid I can't do that because what's happened subsequent to you being called on your guarantee is that the relationship is now fair between the debtor and the creditor, and so I'm afraid you have no claim. That is one of the consequences of learned friends analysis. And as regards the bankruptcy example we gave, we agree that on bankruptcy, the cause of action vests in the trustee in bankruptcy. There's no dispute about that. That's our own positive case. But the relationship between the creditor and the debtor continues. Debtor is not discharged on the making of a bankruptcy order. Now, the debtor may have new claims based on post-bankruptcy conduct. Those are after acquired property. But the debtor will usually, after a period of time, a year, be discharged and the relationship ends. And that obviously radically changes the fairness of the relationship at that point in time. Effectively, the debtor has got money for nothing. But the accrued rights that the debtor had for unfairness prior to his bankruptcy, which vests in the trustee in bankruptcy, that is a cause of action, which in our submission should be assessed as at the date of the bankruptcy, and that could not be met. Trustee's claim could not be met by a defence saying, well, actually, the relationship is now fair, so you, trustee, have no cause of action. So the issue is not whether the claim vests, it does, but whether the trustee's claim ought to be judged by reference to post-bankruptcy events, and in our submission, it shouldn't. It's another indication why we say a hard and fast rule that you must have only one determination at the end of the credit relationship cannot be right. Now, in my learned friend's written case at paragraphs 41 to 42, they say that the Court of Appeals analysis requires the court to ignore all facts of the relationship. They say that facts were ignored after 2006 and 2008, but the Court of Appeal didn't ignore any facts. If one goes to page 169 of paragraph 45. Court of Appeal said expressly.
Which paragraph, sorry?
Sorry, paragraph 45 on page 169. So it did take into account all the facts at paragraph 45, but it went on to conclude that in paragraphs 66 to 68 on page 174, that having been unfair up to April 2006, after the final sum referable to PPI was paid off, then the relationship was fair. And Lord, I want to just take a look at Patel and Scotland, if I may.
I mean, does it follow from the Court of Appeals analysis that if the claim had been brought just after the last payment had been made, it still would have failed because the relationship was now fair?
No, my Lord. No. The Court of Appeal is clear that there was an accrued right of action. You could look back at the relationship when there was a PPI policy and payments being made to it, and indeed an outstanding balance on the credit card referable to PPI, and the debtor could have brought a claim in respect of that. They had 6 years to do so.
And that would have been a claim in respect of a past relationship, would it? Was it not the current relationship at the time?
It's in respect of a past unfairness which has now ended, my Lord, and it can also be said it's in respect of a different relationship which arises out of two agreements, not one. So it's two points, my Lord. They are the relationship has changed in a very significant way, and one of the reasons why it's changed is because you're now dealing with simply a credit card as opposed to a credit card and a related PPI policy. Now, Lord, just dealing with Patel and Patel decision of which will be very well known to us, Lord Leggett. At 172 of Court of Appeal's judgment, Lord Justice Burse said at 58, after quoting paragraph 66 of Patel, which is at the top of the page, at 58, the second point is that I would not say that the relevant date always and necessarily has to be the date when the relationship ended, assuming it's come to an end and by the time the court considers the matter. I do not think paragraph 65 means that. That's 65 in Patel, but if it does, then I respectfully disagree. Looking at the matter that way was undoubtedly appropriate in Patel, and may well be the right date in most cases, but in my judgment, for the reasons addressed below under the heading compartmentalisation, the 1974 Act does not preclude a finding that a relationship can change over time. And we respectfully endorse that analysis. The Patel was an extreme case, but it's page 506, and it's worth, in my submission, looking at what the facts of that case were. Notably, it didn't deal with a situation where the unfairness ends many years before the claim is adjudicated upon. It didn't deal with the limitation points that are being raised in this case because they weren't argued. A completely different point was argued, as we'll come on to see. But as my learned friend referred to earlier on, there were two loans made back in 1979 and 1983, the West loan and the Mondis loan. In 1992, those were consolidated, and we get that from paragraph 27 on page 514. And it's at paragraph 73 where the analysis of unfairness took place. And it's a long series of sub-paragraphs. But if I could just highlight some of the unfairness that was found. And the point is, this was a case of continuing unfairness all the way up to, and indeed including, trial. In fact, one of the facts of the case was that when the claim was issued, 4.5 million was claimed. By the time the case had got to trial, over 6 million was being claimed because compound interest at 20% per annum, compounded monthly, was still being claimed. And as my Lord Leggett has pointed out, at 74.2, this is on page 527, the elements of unfairness, which are described as in 74, third line down, as substantially increasing the unfairness of the relationship, included 74.1, not making any written record of the agreement. 74.2, not providing the record to the debtor. 74.3, again still on page 527, not providing any statements to the debtor. 74.4, asking for only sporadic and small repayments in 1998 and 2001. That's at the top of page 508. And that then led to the conclusion at the bottom, the second half of paragraph 74.4, where it said the effect of this approach in circumstances where no reminders or calculations of the amount outstanding were being sent was to encourage the defendant not to pay the interest accruing on the loan, and also to foster a not unreasonable hope, which would have gathered strength as time went on, that the claimant was not going to assist on payment in accordance with the terms agreed in 1992. The unfairness which this caused to the defendant increased as the years went by. The longer the claimant said nothing about any repayment, the more reasonable it became for the defendant to think that the terms already agreed in 1992 would not be enforced, while at the same time the faster the debt was growing through the compounding of interest. These were, as I say, unfair acts and omissions all the way up to trial, and as the Court of Appeal itself said, it was endorsed the approach of Lord Leggett, that the assessment had to take place based on the current relationship. There were acts of unfairness that were taking place all the way right up until trial. Now, the claimant in Patel did try to run a limitation argument, and that's at page 522, which is at paragraphs 58 and 59, which is where the argument is summarised, 58 and 59. And that is not an argument that we are making today. In short, what was being argued was that, by analogy with the extortionate credit bargain legislation, the time for bringing any claim under section 140A-C commences on the date the credit agreement was entered into. Rather oddly, it seemed to be the claimant's case in there, in Patel, that the cause of action accrued before the statute even came into force. As I say, that's not an argument that the bank runs in this case, and it was roundly rejected in paragraphs 61 to 63, pointing out that the words in section 140C, so this is on paragraphs 61 to 63, which are on page 523, that the court is entitled to have regard to matters arising after the credit agreement is entered into, and that is what the Court of Appeal did in this case. But there is a very significant difference between the facts in Smith and Burrell's cases and Patel. Patel was not a case like Smith and Burrell, where the unfairness complained of took place many years before the claim form was issued. The unfairness was continuing in Patel, not least because of the 20% compound interest per month that was being added to the claim. And on the facts of Patel, it's readily apparent why the determination of whether the relationship was fair or unfair took place at trial, particularly when the balance was ever increasing. But we respectfully submit that, as Lord Justice Burse held in paragraph 58, that doesn't mean that all cases require that there is only one determination of fairness, and that can only take place at trial regardless of the facts. Now, paragraph 66 in Patel at page 524. I just might invite your lordships to read that paragraph, and in particular the reference to there being a continuing cause of action. Now, at page 132 of the bundle, we have set out what is meant by a continuing cause of action. It's in our written case, and it refers to the case of Hole and Chard, decided by the Court of Appeal.
Could you give me the page number again, please?
132 of the bundle.
Thank you.
And it's paragraph 86. And we've quoted from Hole and Chard, what is a continuing cause of action? Speaking accurately, there is no such thing. What is called a continuing cause of action is a cause of action which arises from the repetition of acts or omissions of the same kind as that for which the action was brought. And on the facts of Patel, one can see why that was an entirely apposite description of what the relationship was, because the creditor was continually adding, for example, compound interest to the debt. And each time that unfair act took place, then there was a continuing unfairness, which gave the debtor the right to apply to court and seek the order that was sought. That is not the situation involving the claims in respect of Miss Smith and Mr. Burrell. There were no repeated acts after April 2006 in respect of Miss Smith, and no repeated acts after March 2008 in respect of Mr. Burrell. nothing at all relevant to their causes of action took place after those dates. And as the Court of Appeal held, when the unfairness arising out of the PPI policy ended, that was the latest date on which the cause of action accrued to recover the payments made in respect of PPI. Now, the case of Scotland, again, in our respectful submission, doesn't undermine the analysis of the Court of Appeal in Smith and Burrell. In short, the issue decided by Scotland was that when determining whether a relationship is unfair, all the facts have to be taken into account without temporal restriction. So, in that case, a PPI policy had been induced by a misrepresentation which is attributed to the creditor, and the misrepresentation was that a single premium PPI policy was a requirement to secure the loan for the double glazing. The cost of the PPI was added to the loan. In truth, it wasn't a requirement to take out PPI, and the trial judge found that the claimants would not have taken out PPI but for the misrepresentation. The only issue that was argued before Scotland is whether it was right to take into account the misrepresentation at all. So, cases at 561. And we need paragraphs 81 and 82. Which are on page 583. It starts at paragraph 80 on this page, where it records the submission that was made. I invite your lordships, please, to read 80 and 81. So the claim that was being, or the argument that was being advanced in Scotland was that because the misrepresentation made on behalf of the creditor had been made more than 6 years prior to the commencement of proceedings, it was likely that the creditor's right of recourse against the broker who made the misrepresentation would be time barred, and so it was said, well, you should ignore that misrepresentation when determining whether the relationship between the creditor and debtor is fair. And Lord Justice Kitchen, as he then was, rejected that in paragraph 82, and
suppose that in the point had been taken in Scotland and it had been said, oh, well, you can't get back the interest payments you made more than 6 years ago because those are time barred. You say that would have been a good argument that should have been accepted?
No, my Lord, on the Court of Appeals analysis, those sums are recoverable because at the date of trial, there was an unfair relationship referable to PPI. The loan, which was outstanding at trial, included a balance referable to PPI. And the Court of Appeals analysis is, well, that is unfairness arising out of
it's probably likely, isn't it, that all the facts necessary to establish a claim for repayment of the interest and the principal, for that matter, it existed more than 6 years ago.
Well, my Lord, they, as I say, that's on
your alternative analysis, it would be time barred, would it?
On the alternative analysis, my Lord, in relation to Section 9, then there would be part of the interest which could not be recoverable as an action to recover money, because part of it was more than 6 years that had been paid more than 6 years ago.
And the principal as well, presumably. Oh, sorry, they were just paying interest on the loan.
No,
Oh, no, they didn't.
no, Lord. The sum that was outstanding.
So they'd only. Sorry, I got confused. It's that the payments they made more than 6 years ago couldn't be recovered, but anything they hadn't on the alternative analysis. But anything they hadn't repaid, they'd still be entitled to argue they shouldn't have to repay.
Reasonable, because they could,
Absolutely, yeah.
on the Court of Appeals analysis, they can come to the court and say, look, my loan is inflated by a PPI premium, which I would never have incurred but for the misrepresentation that was made to me. I've never taken out this policy, so my relationship would never have included this premium referable to PPI. As regards the point that Scotland decides, which is that, well, you do take into account facts that occurred more than 6 years ago. You take into account the misrepresentation in order to assess whether the relationship now is unfair. That was something that the Court of Appeal in Smith and Burrell agreed with. And we get that from paragraph, this is page 168 in the bundle. And it's paragraph 44, right at the end. Really need to pick it up with the last line of paragraph 44, which is the Court of Appeal rejected this submission, a submission that you shouldn't take into account. You'd exclude from your consideration the misrepresentation. Then Scotland, paragraph 82 is quoted. You don't need to read that again. And, paragraph 45, Lord Justice Burr says, I respectfully agree with this analysis. So his analysis was entirely based on or consistent with the point that was decided in Scotland. And so the point that Lord Justice Burr decided was not one that was before the Court of Appeal in Scotland and wasn't decided by the Court of Appeal in Scotland. And we get that from paragraph 63 of Lord Justice Burr's judgment, which is at page 173 of the bundle. Where he said this at 3 lines down: Scotland was another example of conduct years beforehand having effects continuing over a long time and supporting a finding of unfairness at trial. The loan in Scotland to cover the PPI payments which had been induced by the misrepresentation was still outstanding, at least in part, when the case came to trial. It is clearly correct that the court must consider the whole relationship when deciding whether the relationship is unfair at the relevant moment that the question arises, and on facts like those in Scotland and Patel, consideration of the whole relationship over time leads to a finding that it is unfair at the relevant moment. However, that does not mean a court, having carried out that exercise, is constrained to compartmentalise the outcomes into one of only 2 possibilities: that the entire relationship is fair or is unfair, and no other outcome is possible. And in our respectful submission, the Court of Appeal's approach is correct and produces a fair result. Ms. Smith and Mr. Burrell had 6 years to bring a claim for repayment of the monies paid in respect of PPI after the date when the PPI policies ended and no sums referable to them were outstanding. So 6 years after the last sum referable to PPI is paid off. And that, in our submission, is an appropriate limitation period. And if there are any facts which were, for example, deliberately concealed, the consumer can rely on Section 32. The contrary approach, Malone and Friends approach, is that it permits claimants to claim money literally decades after the money was paid. In our submission, there is no justification for this. So we respectfully ask the Supreme Court to uphold the Court of Appeal's decision on limitation. Now, a learned friend, paragraph in his written case at 70 to 71, takes a point about whether Mrs. Smith had any cause of action at all. And he says this creates this black hole. And we've addressed that in detail in paragraphs 109 to 112. And I won't repeat that. In short, Mrs. Smith never had an extortionate credit bargain claim, but if she did, she had an accrued right that was not taken away from her. Three points to stress on this. First of all, the hypothetical postulated by my learned friend is a rare case, namely that the borrower had an extortionate credit bargain claim before Section 140A to C came into force. It ceased to be extortionate before Section 140A to C came into force, and the credit agreement continued after the 6th of April 2007. It's only in those circumstances that his argument runs. Because if, for example, the credit agreement was extortionate before and after Section 148 to C came into force, it was extortionate before and after, then the borrower would have a claim under Section 140 A to C, because the relationship would be unfair after the Act came into force. The second point to note on my learned friend's case is that the introduction of 140 A to C generated for consumers unfair relationships claims based on historic conduct which didn't give rise to any claim before the 6th of April 2007, and historic conduct which gave rise to an extortionate credit bargain claim which had since become time-barred before Section 148C came into force. And perhaps to try to illuminate that submission, imagine a lender under a 25-year variable rate loan charges an extortionate rate of interest between 1990 and 1993. Thereafter, the loan continues at a fair rate up to the 6th of April 2007 when the Consumer Credit Act comes into force, and after that. On the learned friend's case, that borrower acquired an unfair relationship claim, even though that claim would have been time-barred under the extortionate credit bargain legislation. And we respectfully submit that cannot be right. And Lord Justice Burse identified the solution to this issue in the concept of accrued rights, which preserve accrued rights to extortionate credit bargain claims, but also give the creditor accrued limitation defences as well to those extortionate credit bargain claims. And the third point I wish to stress in respect of this part of the argument is that even if a learned friend is right that Miss Smith did acquire an unfair relationship claim on the 6th of April 2008, so at the end of the transitional period, that doesn't undermine the Court of Appeal's limitation analysis. They're two completely separate points. My learned friend is right that Miss Smith did acquire a claim under section 148 to C, that is time barred, just as Mr. Burrell's claim is time barred. My learned friend's argument about this simply means that section 148C has greater retrospectivity than the Court of Appeal provisionally thought. That's the only point that, about retrospectivity, and when a consumer acquires a section 148C claim in respect of things that happened before the Act came into force in 2007. The Court of Appeal say you've got to show unfairness after that date. If that's wrong, their analysis as to when the cause of action accrues and when it ends is unaffected. As I say, it's just simply a question on the retrospectivity aspect of section 148C. So, having gone through the Court of Appeal's analysis on limitation, we do have an alternative case, which I'll summarise fairly shortly because I think we've been over it already. But the planks of the argument are that, first of all, the cause of action is every fact which would be necessary for the plaintiff to prove, if traversed, in order to support his right to a judgment of the court. It accrues when all facts that make it up can be pleaded. The question then is, what are the facts necessary for the claimants to make out their claim, and when did they arise? And we suggest that Limitation Act requires the court to establish when the facts first occurred necessary to plead the claim. Unfairness is not a fact, it's a legal conclusion to be drawn from primary facts. If we look at page 377, bundle, which is section 140A. Section 140A describes unfairness as something that the court determines. And the determination has to be on the basis of one or more points listed in subparagraphs A to C. Those are the underlying facts, at least one of those of which the claimant must allege. Section 140A2 says that the court may take into account other matters. Again, those are other facts. In short, an allegation that an unfair relationship exists is more complicated than a bald assertion that it is unfair. It's a determination that the debtor invites the court to make based on the underlying facts of which complaint is made. The second point is that the cases tell us that a claimant does indeed have to plead more than simply that the relationship is unfair. And we've quoted a paragraph at page 117 of our written case, the case of Campbell and Tyrell, page 117 of the bundle, paragraph 90 of our written case. I invite your lordship just to read how a claim is.
Paragraph?
It's paragraph 90. Oh, sorry.
Paragraph 90 is 133.
38 too, I'm sorry.
38.
Paragraph 38.
Yes. Sorry. The third point is that there is a distinction between a cause of action which is composed of the facts and the legal label that is applied to those facts. And this is our written case at page 114 of the bundle, paragraph 28. And this is a quotation from Lord Reed in the case of Central Asbestos and Dodd, which in our submission makes the point that what is a cause of action is the facts on which the cause of action arises, not the legal label that you apply to those facts. So, for example, taking a completely different area of the law, it's common parlance to say that, for example, a doctor has been negligent, but the cause of action is constituted by the facts, and the facts may reveal more than one cause of action. A claim in negligence against a doctor may be that the cause of action is the failure to diagnose. That's the first cause of action for a period of, say, 6 months. But when the condition is diagnosed correctly, the doctor may prescribe the wrong treatment. That's a claim in negligence, but in fact there are two causes of action. The underlying facts are different, and the legal label that's applied to that cause of action is simply negligence, but the limitation purpose is there are two causes of action. So, going back to our example referred to earlier on of a borrower's cause of action for under their car loan, they have a claim for repayment of interest, unfair interest paid in year 1, which is different from their claim to recover possession of their car that arises in year 7. Both of those can be described as claims for relief from an unfair relationship, but they are in truth two separate causes of action. They're based on different facts. The fourth point is that, which I've already covered, I think, but I will just give your Lordship's reference to the case. The fact that the court is making a discretionary assessment whether it decides on whether there is any claim at all or whether any remedy is appropriate doesn't change or postpone the date when the cause of action accrues. The cause of action accrues when the debtor has the right to make the application to the court asking it to make an order under section 140A to C. And I've already referred to Re-Farmiser, which made that point, but Hillingdon versus ARC, which is at page 430 of the bundle, is the relevant case.
Could you give me the page again?
Yes, sorry, my Lord, it's at page 430.
430.
So I just might invite your Lordships to read 430 to 431, just a head note. So the short point, my lords, is that the cause of action for this monetary relief when land had been compulsorily acquired arose when the right to apply to the Lands Tribunal first arose. The fact that the Lands Tribunal had yet to make any determination did not stop the cause of action arising, and the relevant paragraph is at page 441 of Lord Justice Potter's judgment, with whom Lord Justice Murray and Lord Justice Norse agreed. Paragraph 25, it seems to me a number of authorities make clear that for the purposes of limitation, a cause of action may accrue for any sum recoverable by virtue of enactment, although that sum is yet to be quantified by some process of agreement or adjudication. And Justice Potter then went on through paragraphs 26 through to 30 over the next 2 pages to page 443 to look at the cases, all of which support that proposition, including decisions of the House of Lords and West Riding County Council at page 442. And he ended in 31 by referring to Re Farmiser, which I took lordships to earlier on today, endorsing what was said there, where, as looked at earlier on, the claim under section 214, a wrongful trading, involves the court having a discretion whether to make an order at all, and if so, in what amount. And then finally, just page 448, Lord Justice Mummery agreed, and Lord Justice Norse gave a short judgment, which I would invite lordships just to read. Page 448, Lord Justice Norse. So, my lords, on this alternative analysis of limitation, we say applying it to the facts of this case is straightforward. The facts that gave rise to the unfairness with the PPI policy and the non-disclosure of commission, those occurred in 1998 and 2000 for Mr. Burrell and Miss Smith, respectively. Ignoring for a moment the technical point that the statute didn't exist, those points could have been pleaded then. They could then have pleaded the payments made in respect to the PPI policy when they made them. For Ms. Smith, that was between 2000 and 2006, and for Mr. Burrell between 1998 and March 2008. And they were entitled to commence their claims under section 148C on the 6th of April 2008. That's when they could plead all their causes about all the facts necessary to support the claim that they made. But they didn't issue the claim for over 11 years. In our submission on the alternative analysis, that claim is time barred. And on the alternative analysis, the arguments that we've had about whether there can be one determination of fairness or not doesn't matter on this analysis. If all the facts necessary to give rise to the unfairness and remedy occurred outside the limitation period, then the claim is time barred. Equally, the dispute about whether the claimant, having paid PPI premiums in the past, gives rise to unfairness now, that also falls away. Falls away because the relevant facts are the payments of the PPI premium and the causes of action accruing once those occur, however one describes or characterises the relationship after that date. And it also fits in with the continuing cause of action analysis in whole and chard, that a cause of action is a continuing one which arises from repetition of acts or omissions of the same kind. A cause of action for repayment of PPI premium arises each time that the borrower makes a payment. Each payment is the necessary fact that has to be pleaded if the payment is to be recovered. The dawning of a new day is not a fact relevant to that cause of action on its own. It's an irrelevant fact. Cannot give rise to a new cause of action. Of course, if on the dawn of a new day the borrower can point to underlying facts that make the relationship unfair on that date, then they will have a cause of action on that date. For example, if the PPI policy continues from one day to the next and premium is debited to the credit card, the borrower would have a cause of action to reduce the balance on the credit card. But that's different from their claim to recover a payment that they made many years before. And on this alternative analysis, the claims are time barred. It also has the further advantage, we would suggest, that it focuses on when the facts that need to be pleaded first arise, which is one of the tests, the tests that the cases repeatedly refer to under Section 9. So, Lord, I have just the transitional provisions point to deal with. We've dealt with it in our written case at 114 to 125, which is pages 140 of the bundle onwards. Obviously, if a right on limitation, it doesn't matter for this case, or it might well matter for other cases. In our submission, the purpose of the transitional provisions was to give creditors an opportunity over the course of a year to bring to an end an unfair relationship before the 5th of April 2008. If the related agreements which caused a relationship to be unfair ceased to have any effect before the end of the transitional period, there would be no claims in relation to historic unfairness. Now, the relevant transitional provision is in 391. Paragraph 16 of Schedule 3. There's common ground as follows. The transitional period ran for 1 year from the 6th of April 2007, when the Act came into force, until the 5th of April 2008. It's common ground that the PPI policies cease to have any operation within the meaning of 16.5, which is on page 392. They cease to have any operation during the transitional period. So it's common ground that paragraph 16.4, at the bottom of page 391, applies to the PPI policies. And if I just might invite Lordships to read again, I know you've read it once already, paragraph 16.4. There are two drafting techniques which are employed in this paragraph. The easiest one of which to comprehend is what they say about the taking of an account, which is at the words right at the end, which is that an order shall not, under paragraph G of that subsection, that's section 140, direct accounts to be taken, or in Scotland, an accounting to be made between any persons in relation to a related agreement to which this subparagraph applies. And I don't think we need to go to it, but section 140 B1G gives the court power to order an account. That's at page 379. And what this transitional provision says in terms is that the court is prohibited from ordering an account between any persons in relation to these PPI policies.
Sorry, which page are you on now?
Sorry, so I was on
3912.
So it was 379. Yeah, we're on 392 for section 16.4.
Yeah.
And then 379, just to remind ourselves of what paragraph 140B1G
Yeah,
says.
thank you, I've got it.
The court may direct accounts to be taken, or in Scotland, an accounting to be made between any persons. And what the transitional provisions say is you cannot, court, make that order in relation to a related agreement that has ended before the 6th of April 2008.
I mean, the point that's taken against you is all these payments were found to have been made under the credit agreement, and that therefore they don't need, the fact you can't make an order under the related agreement doesn't matter.
Well, Lord, that is the point that is taken.
Well, what's wrong with it?
well, my Lord, it would undermine the statutory purpose of this provision if those payments that were made, which were paid by virtue of the PPI policy, could be recovered in this way, because the purpose of these transitional provisions was to give lenders a period of time to get rid of agreements which made their relationships with their customers unfair.
But it said you could have done that here, had you recognised that the relevant agreement you need to get rid of was the credit agreement. You could have said, sorry, we're stopping this credit card, but here's, if you like, a new one. Then it might have worked.
Indeed, the answer. That is, and the question, my Lord, for the court is whether that can possibly have been the intention of Parliament when passing this piece of legislation, that in order to avoid liability for historic PPI policies, it wasn't enough to get rid of the PPI policy before 6th of April 2008. What you needed to do was you needed to terminate all of your credit cards, and not just terminate the credit cards, my Lord, but get repayment of all the sums on the credit card, because if you replaced one credit card with another, then that new credit card would still be subject to the Act, because it would be consolidating the previous agreement, and it would and so therefore claims in respect of historic PPI would still be available. We suggest that can't possibly have been what Parliament intended, and the fact that the court cannot order an account in respect of a PPI policy indicates that it also can't order payments made under a PPI policy. If you can't order an account, then it follows that you shouldn't be ordering payments in respect of that policy. So when one reads section 140B (1)(a) on page 379 of the bundle, you read it without the words "by virtue of the related agreement." If, on analysis, the payments were made by virtue of the related agreement, i.e. by virtue of the PPI policy, then this court has no jurisdiction, or the court has no jurisdiction to order repayments of sums paid by virtue of that PPI policy. And if one asks, why is it that any payments at all are made which are now being challenged, it is because of the PPI policy. Those are the only payments in which any complaint is made. The fact that there was the mechanism by which the payments were made as the credit agreement doesn't, in our submission, justify construing the transitional provisions as permitting recovery of sums paid by virtue of the PPI policy. And we say that relevant context to illustrating the mischief to which the transitional provisions were aimed is the explanatory notes to the Act, which are admissible as an aid to interpreting what was a mischief.
You need to watch your time, Mr. Taylor.
My Lord, this is the last point, my Lord. So it's at page 1259.
It's a case, is that right? Westminster City Council.
Westminster City Council.
I'm sorry. Sorry, it's 1530. I do apologise. 1530. And it's paragraph 112. These are the explanatory notes to the Act. And in particular, my lords, the last paragraph, the transitional period will allow creditors to ensure that any agreement that will continue beyond the end of the transitional period comply with the amended 1974 Act. And on the facts of our case, that's precisely what happened. What happened?
Not precisely, because it didn't have to do anything which you did. It happened through something which the debtor did.
Well, my lord, the PPI agreements were ended. Yeah. So, my lords, in summary, we respectfully ask the Supreme Court to dismiss the claims on the basis of transitional provisions, in addition to the limitation points that I have outlined to your lordships.
Thank you very much, Mr. Taylor. Mr. Weir.
Yes, my Lord. My Lord, I'm going to take it again in the same way, which is to start with the construction of section 140A and B and the arguments which limit themselves really to can you compartmentalise, or I think in the words of my Lord Legate, hive off. I don't mind which terminology is preferred, but that's in substance what's being invited to happen, and what the Court of Appeal did. And secondly, did the unfair relationship acknowledged as such in 2006 become a fair one? So far as concerns section 140A and B and how to approach it in terms of its meaning, we maintain that there is nothing that the Limitation Act has to assist in relation to that task. And I, for my part, cannot understand the application or relevance of the two cases that my learned friend refers to in support of the proposition that the Limitation Act goes to the construction of a statutory cause of action outside the Limitation Act. The Re-Farmisia case you were taken to earlier this afternoon, so I don't have time to take you back to it. But you recall the only issue in which a passage is extracted from the judgment of Peter Gibson, Lord Justice, the only issue was, is there a limitation period at all? That was the argument. The argument was there's no limitation period. And Lord Justice Peter Gibson, in the context of being invited to find there is no limitation period, said, oh, yes, there is. And unsurprisingly says, well, it would be nice to have a limitation period in relation to this issue.
But the argument focused on whether certain words in the Insolvency Act prevailed over any limitation period.
My Lord, That may be an issue of wording between the court.
No, but I mean, you're saying it had nothing to do with the construction of the...
Oh, no, my lord.
Your analogy is the limitation had nothing to do with construction of
No,
insolvency.
the issue was not, and it's just exactly the same point applies in the Legal Services Commission and Rasool with Regulation 86 that says words to the effect of if the Legal Services Certificate is revoked, the Legal Services Commission can recover its monies. No one's sitting there thinking, what does that mean? Recovery of monies, does that mean you can recover? We understand it. We understand exactly what it means. Everyone understands at the stage of inquiry and reformisier what it is that this provision of the Insolvency Act does. So we're not in the prior stage of what is my right of action? What powers do liquidators have under this? What powers does the Legal Services Commission have under Regulation 86? It is entirely obvious what right they have. The question is being asked, secondly, having well understood what it does, and then only in the context of limitation. And in the context of asking in limitation terms, what is my right or do I have a limitation? Then, of course, you undertake questions such as, what's the general policy and purpose of the Limitation Act? This simply doesn't go to this issue at all. And as I say, were it to do so, would you not think there would be more cases in these two very abstruse cases in this context? Wouldn't there be a statement from the House of Lords saying, gosh, you've got a statutory cause of action, make sure you look at the Limitation Act? This would be a novelty in 2022, a complete novelty. It is simply wrong. Secondly, the respondent has, and wisely so from its perspective, barely addressed the wording of Section 140A at all. Barely addressed it. The only submission that I can recall being made about the wording of Section 140A, if you kindly go back to page 377, is a brief and tenuous suggestion that there can be two relationships because the Act says, page 377, if it determines that the relationship between the creditor and the debtor arising out of the agreement, open brackets, or the agreement taken with any related agreement, close brackets, was an indicator that you're dealing with multiple relationships. It isn't. It is a single relationship. It is the relationship between creditor and debtor unfair. When looking at that, you ask yourself, is that relationship, namely one which arises out of the agreement on its own or the agreement taken with a related agreement? It's up to you to argue your case. And if you go to Plevin, if you can kindly go to page 549, just to give this context for the PPI cases. If you go to page 549, please, paragraph 40. The entirety of Plevin was concerned only with the credit agreement. You'll see Lord Sumption says, I record for completeness that Mrs. Plevin did not rely on the reference to any related agreement in section 140(1)(c), either in the courts below or before us. We've therefore not heard argument on whether the PPI policy was a related agreement. It didn't feature. This is the leading case in Supreme Court on the application of section 140A, specifically in the context of non-disclosure of the fact and amount of commissions. And it's a case about credit agreements. And ours is a case about credit agreements. It's a complete red herring, and I'm rushing off now to the transitional provisions, but extracting out that words related agreement have been redacted and saying somehow we fail. We don't have to rely on that at all. But nor can you extract from this some suggestion, very tenuously put, that is in some way an indicator of multiple relationships. There is, and always can only be, a single relationship which has to be assessed by the court. It is a return always to the wording of section 140A. And see the way it was applied in Patel and, for instance, in Nelms. If you go back to the Patel judgment at paragraph 79, we're going to come. So this is page 529. And Patel judgment, you will have noted, was a judgment that my learned friends was at pains not to say was wrong. He was seeking to distinguish it, but he was at pains, and I'm sure it wasn't just to upset the feelings of my Lord Legate, but he was at pains not to say some part of this analysis really is off kilter, it's off key, it's all wrong, it's all very much, the unfairness is ongoing. Well, what actually Lord Legate did in this judgment was he addressed the fairness of the earlier agreement subsequently consolidated. He didn't find unfairness there. So what? He did find unfairness at various different stages, and you were taken through to paragraph 74, which was at page 527, including unfairness with the terms of 1992 agreement, so way back in the day, all the way through. And then what does Lord Legate do, having got these multiple allegations of unfairness at large? He says at paragraph 78, I make a single finding of unfairness. Very in conclusion, the relationship arising out of the 1990 agreement was unfair to the defendant, followed up at page 531, last paragraph, conclusion. The relationship between the parties arising out of the agreement is unfair. It is a single finding. It is the only way. It's the part of the judgment of Mrs. Legate back at paragraph 64, which has been followed through loyally and of which no criticism is made. It has to be a single assessment, and it has to be a single assessment at the last possible moment in time. It's a submission I've already made. How else can you have regard to the whole of the agreement? It is not possible. There was no answer from my learned friend to say, oh, well, the Court of Appeal, subsequently, when they get through to sort of paragraph 68, have a look at the fairness of the agreement after 2006 and say, it's fair. That's not an answer. The point's a point of principle. If you select out a date and say, doesn't matter, 2006, 2008, whenever it is, and you say, I'm making my assessment at this point, by definition, you are not having regard to matters after that point in time. You can't be, because you're saying, I'm looking at fairness now. How can you look at fairness at that point in 2006 and have regard to something that's happened after it? You can't. So that's why I've made the submission that the whole of Section 140A, when you work through the express words that Parliament has chosen to use, require this court to say, I am going to investigate whether the relationship at the end when it's finished, otherwise at trial, is or is not fair. It's a single question, answer yes or no. It's the only way. And what instead we have is really a plea, which is always, it's a plea to limitation. It absolutely lies at the core of the respondent's argument. This can't be how it should work. This doesn't feel right. 25 years this, look how long ago that is. It's a continuous plea to the same thing, to which I say again, please look at the terms of Section 140A, because I've sought to set this out in stages. Section 140A expects the court to have regard to a history which will go back in time a long way. It expects it because it says, is the relationship unfair? Have a look back at even what happens before the related agreement that's the earlier consolidated agreement. And at para 16 of Schedule 3, it says it's immaterial when that earlier agreement was made. So Parliament's telling you that it is of no concern to Parliament at all, no concern, that the court is charged with the task now of looking at fairness now, having regard to matters that maybe had their origins a long time ago. The answer to which, see the observation of my Lord Legate, is twofold. First, it may be that the court determines that means there's no unfairness now. Secondly, it may be that it chooses to exercise its discretion not to provide a monetary or other remedy to the claimant. You see this in Nelms. I haven't taken you to Nelms before, because can I quickly go to Nelms? I think it's at page, well, the key parts are at page 976 and following. So Nelms is a case in which, again, there were multiple allegations of unfairness by the debtor. If you go back to page 959, that's the one that bit, which was, if you look at the top of 959, para 30, it was in April 2007 that the procuration fee, see para 32, forgive the speed at which I'm doing this, that the procuration fee was paid by the creditor to the debtor's agent, see paragraph 34. And the claim was brought, see paragraph 3 on page 952, after July 13, more than 6 years after that payment. And the analysis, first of all, of the judge at first instance, as recorded by the Court of Appeal Judge Lord Justice Clark, who gave the only judgment, see page 976. And this is dealt with approvingly by Lord Justice Clark, para 103. The judge then considered the question of fairness in the round. And then you'll see the judge considers, you see the headings at para 104, in relation to the creditor's conduct before and at the time of the formation of the agreement, then in relation to the conduct after formation and leading up to enforcement. And then if you go over the page to 978, para 111, with the exception of his treatment of the procuration fee, the judge, in my view, is entitled to conclude there was no unfairness. But there was unfairness in relation to a procuration fee paid, not even paid by the debtor. This was one paid by the creditor to the debtor's agent. But that rendered the current relationship unfair, so that the conclusion, para 117, was that the appeal was allowed. I allow the appeal, but only to the extent of giving judgment for the procuration fee plus interest. In other words, it may just be one part, but the relationship was unfair as assessed. The relationship was unfair as a result of conduct more than 6 years ago, just like in Scotland. Money hasn't even left the debtor's bank account in that case, and all this chasing the money and has the debtor paid, and the last date of payment of the debtor is a trigger, is an absolute red herring. It completely misses the target of the function of section 140A, which is not about chasing that penny down as to whether it's even come out of the debtor's bank account, because it may never even have come out of his bank account. It doesn't matter. If the relationship is found to be unfair, then you move to 140B, and the court exercises its discretion whether to provide a remedy. And this looking at the whole relationship, my learned friend accepts. He says the Court of Appeal says you can look at the whole relationship. I took you to that passage myself, and he doesn't demur from it. He says that's right, and Mr. Leggett's right when he says this in para 64. But it's completely at odds with his case. It's inconsistent. You cannot run the two arguments together. You cannot accept that you look at the whole relationship and then seek to compartmentalize it. And what you do when you look at the whole relationship is very clearly set out by Lord Justice Kitchen in Scotland. If you can kindly go to page 585. 585, paragraph 87. And this is an inevitable follow-on from the words of 140A brackets 2. So picking it up between D and E, if there are matters relied on by the debtor which point to the relationship being unfair, the court must clearly take those into account. Any countervailing and the court must clearly take into account any countervailing facts or other matters which put those matters relied on by the debtor into perspective and so may affect the assessment. But at the same time, this is where the creditor says, oh, well, the rest of the agreement's really pretty shiny. But Lord Justice Kitchen quite rightly says, F, the further matters now relied upon by, that's counsel for the creditor, clearly did not contribute to the unfairness of the relationship, but nor, it seems to me, do they diminish or qualify the impact of the matters relied on by the claimants as giving rise to that unfairness. And that is an echo of the language of Lord Sumption in Plevin at paragraph 19. And it's absolutely on point. This is the poisoned well. Once the relationship has been rendered unfair, show me the reason why this relationship is now fair. There has been no submission to this court, oral or in writing, to explain that. All that's said is, well, the last payment was made. That's it. It starts and ends there. So far as concerns the issue of limitation, the appropriate starting point is as Lord Justice Potter set out in the Hillingdon case at paragraph 15, and we reference it in our case, and the reference of that particular judgment is page 438, which is for Section 9 purposes, go to the Act. Not the Limitation Act, go to the Act that you are seeking to construe. So now we're in the world of limitation, in which, respectfully, the observation of my Lord Hodge is absolutely right. Of course, there was a cause of action which accrued in 2006/2008, and had these claimants known about it, perhaps they would have brought their claims in, but they didn't know about it. But the point is, when they bring their claim within 6 years after the end of the relationship, they're not complaining about the relationship in 2006 or 2008. The complaint is about a relationship in 2015. How can it be said that it's not an essential fact of a complaint about a relationship in 2015 that you've reached 2015? That's the point put more eloquently by the Court of Appeal in the passage I took the court to earlier. Of course it's an essential fact. That claim does not arise until 2015. And as I've already submitted, Parliament anticipated exactly the sort of look back that is the underlying fundamental complaint that my learned friend makes. Goodness me, 20 years ago this. Goodness me, I say, Patel. He says Patel is a completely proper judgment, and he hangs that on the basis that there was ongoing unfairness. Well, forgive me, but I don't understand. Is it to be said that provided a debtor who's got old unfairness, as they see it, can also establish that just before 2015 something different happens which gives rise to unfairness, we're in for everything? Because that's Patel. Patel looks back at 1992, way beyond 6 or 12 years. But the only rationale given as to why Patel is nevertheless right and fits with the respondent's case is because there's unfairness in 2010 or 2008 or something. So does it matter now? Is that what's needed to manufacture unfairness? If there's unfairness that's recent, they say, well, you look at the whole of the agreement and you can have it all. That respectfully simply doesn't bear analysis. It cannot be the right way to look at it. It's not a question of picking a piece of unfairness and saying this unfairness is a 2008 piece of unfairness. It's a question of saying, is the relationship now unfair as a result of conduct which has taken place before? And if someone, as a result of that conduct, unfairly extracts from you the full amount of a PPI payment which they should not have done, and keeps it from you, coupled with the information that they've done this, what's not to say that relationship is unfair? There is no counterweight. Well, because of, and I do very, very much appreciate the generosity of the court in allowing me just.
We had some technical difficulties, which is why I've making sure you have your 20 minutes, but you almost have.
Absolutely, and I'm extremely grateful, Lord. On transitional provisions, apart from simply maintaining my case and saying that if the creditor says that's the end of the agreement, they say that's the end of the agreement, you must pay up. You pay up and then they start a new agreement. That new agreement's not a consolidated agreement because it's not linked to the old agreement, it's just a new agreement. So I'm afraid that simply wasn't an answer at all. And the real point is, the wording of Parliament is plain. And it's that they're literally asking this court to ignore it. If Parliament had wanted to achieve the outcome that my learned friend says it should have achieved, it would be very straightforward to draft, much more elegantly than I'm about to, but words to these effect. It would be simply, if a payment has been made by virtue of a related agreement, whether or not also by virtue of a credit agreement, no claim in relation to that payment shall be made, or recoverable, or such like. That's all it's got to say, because that's what the respondent's case reduces to. Although the Act, if you take the Act, redact it, per paragraph 16, print it off, says, by virtue of the credit agreement, they're saying it doesn't mean what it says. They're saying what it really means is, if the monies are also by virtue of the related agreement, whether or not also by virtue of the credit agreement, they are irrecoverable. Very straightforward to plead, let alone for the skills of parliamentary draftsmen. Unless I can assist further, those are the appellant submissions in reply.
Mr. Weir, thank you very much. Well, the court is very grateful to counsel for their thoughtful and clear submissions. The court is also very grateful to those who assisted counsel in the preparation of those submissions and in the preparation of the papers, whether in hard or electronic form, for the purpose of this appeal. A very interesting point has been raised, and the court will take time to consider what the correct answer may be. The court will now adjourn.